Is it live? All right, good afternoon, all of you. So, in the last lecture, we discussed about judicial review, right? The meaning of judicial review, the scope of judicial review, importance of judicial review. In this lecture, we are going to discuss one of the most important topics of Indian polity, and that is basic structure doctrine. I believe, UPSC has some favorite themes, or it has some bias towards some topics, and basic structure doctrine is one topic which UPSC really likes. So UPSC have asked many questions both in prelims as well as in mains from this topic of basic structure doctrine. It's a fascinating doctrine. Now, why I am saying this? Now, why UPSC? And before I proceed, let me tell you, UPSC does not repeat questions, but UPSC repeats themes. And basic structure doctrine is one such theme which is repeated by the UPSC in one way or the other way. So that's why this topic becomes very, very important from examination point of view. Now, why this doctrine is fascinating? One thing which has had a lasting impact on the evolution of the Constitution of India, then that is basic structure doctrine. If one thing that has changed the course of constitutional history of India, then it is the doctrine of basic structure. Now, what is this doctrine all about, right? Let us understand what is the subject matter. What is the subject matter of this basic structure doctrine? Now, I hope you know that doctrine means set of ideas and beliefs, right? Now, the subject matter of basic structure is scope and extent of the power of Parliament. Please write it down. Scope and extent of the power of Parliament to amend the Constitution including fundamental rights under Article 368 of the Indian Constitution. Now, this is the subject matter. Scope and extent of power of Parliament to amend the Constitution, including fundamental rights conferred by Part 3 of the Indian Constitution under Article 368. So, let me simplify. So, the basic structure doctrine, it gives answer to the question, number one, whether the Parliament has any power to amend the Constitution, including the fundamental rights, whether Parliament can amend the fundamental rights under Article 368. Second, does the power of Parliament to amend the Constitution under Article 368 limited or unlimited? And if it is limited, then to what extent it is limited? That is what basic structure doctrine is all about. So basic structure doctrine is about scope. What is the scope of power of Parliament to amend the Constitution, including fundamental rights under Article 368? Whether that scope is very broad, whether the scope is unlimited or limited, right? And the extent, to what extent Parliament enjoys power to amend the Constitution, including fundamental rights. Right? So this is what is the basic subject matter of basic structure doctrine. Now, before I discuss the evolution of basic structure doctrine, let me tell you that, the doctrine of basic structure, it is nowhere mentioned in the Constitution of India. The doctrine of basic structure is a result of judicial interpretation. It is a case of judicial innovation Yes, the basic structure doctrine is nowhere explicitly mentioned in any of the provisions of the Constitution of India. The basic structure doctrine is a result of creative interpretation of the Constitution by judiciary. It is a case of judicial innovation or judiciary. It is a result of judicial innovation or judicial creativity. Now, Supreme Court of India gave this doctrine of basic structure in a landmark and historic case known as Kesavananda Bharati. You must have heard this case n number of times. Kesavananda Bharati versus State of Kerala, 1973. It was this case in which Supreme Court gave the basic structure doctrine, right? Now I hope these are the basic things about the doctrine of basic structure. I have discussed the scope and extent, I have discussed the meaning of basic structure doctrine, what exactly it deals with. Second, I have also told you about in which case the basic structure doctrine was given by the Supreme Court, right? And I have also told you that it is nowhere explicitly mentioned in the in the Constitution of India. The way the word federal is nowhere mentioned, right? The word budget is not mentioned. So similarly, the basic structure doctrine is nowhere mentioned explicitly in the Constitution. Now let us discuss the evolution of basic structure doctrine. It is not as if all of a sudden Supreme Court of India gave the doctrine of basic structure in 1973, Kesavananda Bharati case, right? It has the basic structure doctrine is it evolved through a number of a Supreme Court case, and that particular evolution reached at its zenith in the Kesavananda Bharati versus State of Kerala case. Right? So let us understand the evolution, how it evolved. In this, we are going to discuss various different cases, right? Before we understand different cases, we need to understand two articles of the Indian Constitution. These are very, very important in order to understand the basic structure doctrine. Now, first is Article 368. I have already discussed this article. We have discussed about procedure to amend the Constitution, different types of amendments, so on and so forth. Now, what is the Article 368? Now, Article 368 is about power of Parliament to amend the Constitution. This is the English class, Pawan, but I hope you will understand. Yes, good morning. Good morning, Pawan. So, power of Parliament to amend the Constitution and the procedure. Therefore, this is what is the Article 368. So, Article 368 empowers the Parliament to amend the Constitution, including fundamental rights, as simple as that, right? So, Article 368 empowers Parliament to amend the Constitution as a whole, right, including the fundamental rights. Okay? Now, the question which arose after the commencement of the Constitution was, or even before that, was whether this power of Parliament to amend the Constitution also includes power to amend the fundamental rights conferred by Part 3 or not. This was the question which arose since immediately after the independence, and I am going to discuss the various cases in which this question arose. But this is what Article 360 is, right? It empowers the Parliament to amend the Constitution, and it also deals with the procedure, right? Now, next article that is very important in order to understand basic structure doctrine is Article 13, Clause 2, right? Now, again, I want you to write this article. Article 13, Clause 2 states that state shall not make any law that takes away or abridges any of the fundamental rights, any of the any of the fundamental rights conferred by part 3. See, article 13 is within part 3, conferred by part 3, which deals with fundamental right. State shall not make any law that takes away or abrogates any of the fundamental rights conferred by part 3 of the Indian Constitution, and any law, I am writing the law, expression law, in single inverted commas because it was the meaning. What does the expression law means? This is what was answered in various Supreme Court cases, right? Any law made in contravention of this, rule, right, shall to the extent of such contravention, be declared null and void. This is what Article 13 Clause 2 is all about. Let me explain this. Now, Article 13 Clause 2 states that state shall not make any law that takes away or abrogates or violates any of the fundamental rights conferred by part 3 of the Indian Constitution, right? State shall not pass any law that violates the fundamental rights conferred by part 3 of the Indian Constitution, and in case the state passes such law, then such law which violates or contravenes the fundamental rights guaranteed by part 3, then such law, to the extent of such contravention, will be declared as null and void, will be considered as null and void. It will be considered as unconstitutional, illegal, it cannot be implemented. Right? Got it? This is what Article 13 Clause 2 is all about. Now, let me tell you what is the meaning of the term to the extent of such contravention. What is the meaning of this to the extent of such contravention? See, any law has multiple provisions. It has multiple sections, clauses, subclauses. Now, it might happen that the entire provisions, all the provisions of law itself, they violate Article 13 Clause 2. That is, they violate the fundamental rights conferred by Part 3 of the Indian Constitution. So that is why the entire law will be declared as unconstitutional and void according to Article 13 Clause 2. Why? Because it violates, all the provisions violate the fundamental rights of the Constitution. But there might be a law in which only few provisions of the law or few clauses of the law violates the fundamental rights. Suppose a particular law has 10 clauses. Now, out of 10 clauses, only 5 clauses violate the fundamental rights under Part 3 of the Indian Constitution. And the other 5 clauses, they do not violate the fundamental rights. Then, in that case, not the entire law will be declared as null and void. Only those 5 clauses of that law which violates the Article 13 Clause 2 will be declared as null and void. So that is called as to the extent of such contravention, right? To what extent that law violates the fundamental rights, only to that extent and not the entire law. If all the clauses, if all the provisions violate the fundamental rights, then the entire law will be declared as null and void. But it might happen that some provisions of that law, they do not violate fundamental rights, but some provisions, they violate fundamental rights. So only those provisions will be declared as null and void and not the entire law. Got it? Clear? Fine. So now we have understood Article 368 and we have understood Article 13 Clause 2. Now, why I wrote the expression law in single inverted comma? Because the question was whether the expression law In various Supreme Court cases, the question was whether the expression law also includes the constitutional amendment acts passed by the parliament under Article 368. Because if the expression law includes the constitutional amendment acts passed under Article 368, then Parliament do not have, or Parliament will not have any power to amend the fundamental rights. Because what does Article 13 clause 2 says? State shall not make any law that takes away or abridges the fundamental rights. So if the expression law includes constitutional amendment acts under Article 368, then it would mean that Parliament cannot amend fundamental rights. Right? Because of the Article 13 clause 2. Now this was the question which sought to be answered by Supreme Court in number of cases. Okay? Now in this context, it is very important to understand Article 13 clause 3. Now Article 13 clause 3 states that the expression law includes following things. Okay? Number 1, the expression law, good afternoon, don't come late. Number 1, statutory laws which are permanent laws passed by Parliament or state legislature. The expression law, Article 13 clause 3 states that the expression law includes following things. Number 1, permanent laws passed by Parliament or state legislature. These are called as statutory laws. Right to Information Act 2005. It's a statutory law. It's a permanent law passed by the Parliament. Okay? Then temporary laws. Temporary laws it includes ordinances. Ordinances are promulgated by the President of India under Article 123 of the Indian Constitution and Governor under Article 213 of the Indian Constitution. Right? So, and ordinances are temporary laws, unlike permanent laws. Right? Statutory laws are permanent in nature. Ordinance, they are valid only for a limited period of time. Maximum validity is 6 months, 6 weeks. Okay? Third, it includes statutory instruments. Statutory instruments, I want you to write down this. Statutory instruments in nature of subordinate legislation. Subordinate or delegated legislation. I told you about this delegated legislation. It will include what? What will include this? What is the subordinate legislation? बताया था मैंने? Revise किया करो. It will include rules, orders, directions, notification, etc. issued by whom? Issued by executives. Yes, sorry for my handwriting, I'm not able to actually this. Okay, issued by executive. Sorry. ठीक है, ये एक आएगा. This will also include in the expression of law. The expression law will also include rules, regulations, orders, directions, etc. issued by the executive. That is called as subordinate legislation. Fourth, it will also include bylaws. Bylaws are enacted by the lesser legislatures, like municipalities or panchayati raj institutions. Then fourth, this is fifth. It will also include non-legislative sources of law. Non-legislative sources of law. It will include customs and usages. Customs and usages which enjoy force of law. Right? So Article 13 Clause 2, got it? State shall not make any law that takes away or abridges any of the fundamental rights. Article 13 Clause 3 says, what does law means? So expression law includes, number 1, permanent laws passed by the parliament and state legislature. Second, temporary laws like ordinances. Okay? Third, it also includes various rules, regulations, orders, directions, notifications issued by the executive from time to time. Okay? Then it also includes bylaws passed by the municipalities and the panchayats. And bylaws are inferior laws. Bylaws are inferior when it comes to, as compared to the statutory laws or the ordinances. Their status is inferior. Right? Got it? Okay? Then it also includes customs and usages, some customs and usages which enjoy the force of law. For example, in Hindus, if a couple, it revolves around the fire for 7, moves around the fire for 7 times, then they are considered as legally wedded. Now this is the custom, but it has a force of law. So even customs and usages, those customs and usages which have force of law, they are also included under the expression law under Article 13 Clause 3. Got it? Okay? But it is silent about whether Constitutional Amendment Act also included within the expression law. Okay? And we will discuss that how later on Article 13 Clause 4 was inserted, and which said that okay, expression law also includes constitutional, the expression law does not include Constitutional Amendment Act. This is what we are going to see, but as of now, just remember Article 13 Clause 2 and Article 13 Clause 3. So if Parliament passes any law, if state legislature passes any law, or if President issues any ordinances, or if the executive issues any rules, directions, or any bylaws, if all these they take away or abridge any of the fundamental rights guaranteed by Part 3, then they will be declared as null and void to the extent of such contravention of fundamental rights. Okay? Right? So what Article 13 Clause 2 does is that it protects the fundamental rights of the citizens from being violated, from being taken away by the state. Okay? Article 13 Clause 2 protects the fundamental rights. Okay? And if the state passes any law which takes away or abridges the fundamental rights, then that particular law will be declared as null and void to the extent of such contravention of fundamental rights by that law. Right? Okay? That is what is about Article 13 Clause 3. 368 समझ में आया, 13 Clause 2 समझ में आया, 13 Clause 3 समझ में आया. Now let us discuss about the evolution of the basic structure doctrine. Now, after the independence, the government of India adopted the policy of land reforms. Land reforms which also included abolition of zamindari system. You must have studied in history that the zamindari system was extremely exploitative. Right? So after the independence, government of India adopted the policy of land reforms. Now what is land reforms? Basically land reform means the policy of changing the pattern of land holding by transferring the surplus land owned by landlords and zamindars and redistributing it to poor landless agricultural laborers and peasants. Right? So that is what land reform means. Taking away the surplus land from the rich and powerful landlords and zamindars and redistributing it amongst those who are landless. Right? So the basic purpose of land reforms was to ensure equitable distribution of land. Got it? Now, what happened is that, now you know, land, the land is a subject which is mentioned in the state list under the 7th schedule of Indian Constitution. So Union government adopted the policy of land reforms, and on the basis of the policy of land reforms, government requested the state legislatures to make legislation or to pass laws to give effect to the land reform policy, because parliament cannot make laws on the matters mentioned, enumerated in the state list. Land is a state subject, right? So land reform policy was adopted by the central government, and to give effect to that land reform policy, various state legislatures passed land reforms and zamindari abolition laws. Got it? Because if you want to take away some surplus land, and so how it should be done, what are the rules, so on and so forth, you have to pass law for that. And only state legislature can pass that law. Why? Because land is a state subject. Now what happened? The land reform laws, or the land reform laws or zamindari abolition laws passed by 3 states, MP, UP and Bihar, they were challenged in the high courts of Bhopal, Allahabad and Patna. The constitutional validity of land reform laws passed by these 3 states were challenged by the landlords and zamindars in these 3 high courts. They said that these land reform laws or zamindari abolition laws passed by the state legislatures, they are unconstitutional and hence null and void. That is what they argue. Now, what was the basis of their argument? Okay? Now, the landlords or the who were the petitioners, they argue that the land reform policy or land reform laws, they are unconstitutional because they violate following fundamental rights of the Indian of the citizens. Number 1, they say that land reform laws violated Article 14, that gives right to equality before law and equal protection of law to every citizen. Okay? Then they say that it also violated Article 19 clause 1 subclause F. Now under the original constitution, Article 19 clause 1 subclause was there. Currently this has been omitted, it has been repealed by 44th Constitutional Amendment Act 1978. But under original Indian Constitution, Article 19 clause 1 subclause F was there. Now this granted every citizen of India right to acquire, hold and dispose of property. So Article 19 clause 1 subclause F guaranteed fundamental right of property. Okay? Third, they say that it also violated Article 31. Now again, Article 31 was there in the original constitution. Now it is not there. It has been omitted again by 44th Constitutional Amendment Act. But we are talking about the period 1950. We are talking about 1950. So at that time it was there. So Article 31 is about, Article 31 states that it is about compulsory acquisition of property. It states that no person, so it is available to both, it was available to both citizens and foreigners. No person shall be deprived of his property save, meaning except, by authority of law. Right? So Article 31 was about compulsory acquisition of property. Right to property was there as a fundamental right, but it was not unlimited, it was not absolute. So Article 31 states that the property of the person can be deprived, but only under the authority of the law and only for public purpose, and that too the compensation should be given to the person whose property is acquired. That is what was written in Article 31. So the petitioners, they argued that the land reform laws passed by these 3 states, okay, they violate Article 14. Why? Because they argued that not everyone's, it violated right to equality. Why? Because they argued that not everyone's land was taken. Only the land of landlords and zamindars was taken. So अगर कोई पॉलिसी है आपकी तो आप यूनिफॉर्मली उसको अप्लाई करो, राइट? अरिंदम, हेलो, right? Why you are applying that particular policy of land reforms only to some few, right? So they said that it violated right to equality under Article 14. Then they also said that since right to property is a fundamental right, how can you take away our property, that is land? So they say that the land reform laws violated Article 19, Clause 1, Subclause F. They said we had fundamental right to hold the land, and the land reform laws, they sought to take away that land, right? So it violated right to property under Article 19, Clause 1, Subclause F, as well as Article 31. So to sum up, they challenged the constitutional validity of land reform laws passed by these three states on the grounds that they violated right to equality under Article 14 and violated right to property. Violated right to equality under Article 14 and violated right to property under Article 19, Clause 1, Subclause F and Article 31. And hence, they should be declared as unconstitutional under Article 13, Clause 2. Remember, what does Article 13, Clause 2 states? State shall not make any law that takes away or abridges any of the fundamental rights. Now, this land reform laws, they took away or abridged or violated the fundamental rights. And Article 13, Clause 2 says that such laws shall, to the extent of such contravention of fundamental rights, be declared as null and void. So they argued that since the land reform laws, they violate Article 14, Article 19, Clause 1, Subclause F and Article 31, they should be declared as null and void under the provisions of Article 13, Clause 2. Clear? Now, out of these three high courts, the High Court of Allahabad and High Court of Bhopal, they upheld the constitutional validity of land reform laws passed by Madhya Pradesh and Uttar Pradesh respectively. However, the High Court of Patna High Court, in very famous case, Kameshwar Singh versus Province of Bihar, 1950, it declared Bihar Land Reforms Act 1950 as unconstitutional and void under Article 13, Clause 2. See, government argued that yes, citizens enjoy fundamental rights, but there is something called as directive principles of state policy as well, which are fundamental in the governance of the country, and Constitution says that it shall be the duty of the state to use these principles in making laws. That is what government argued. But the Patna High Court in Kameshwar Singh versus Province of Bihar case of 1950 declared Bihar Land Reforms Act 1950 as unconstitutional, null and void, because it violated right to equality. It said that it is discriminatory. The Bihar Land Reforms Act is discriminatory. Why? Because it is discriminatory against the landlords. It discriminated in terms of giving compensation to landlords. That is why it declared as. Now, the problem was that this particular judgment of Patna High Court was a big setback to the land reform policy of the central government. It means that central government it means that the state legislatures, they cannot implement the land reform policy. They cannot implement the abolition of zamindari policy. Why? Because the Patna High Court declared that such laws are unconstitutional. Now herein started the tussle between what we can call as the parliament and the judiciary. Right? So very few people know that the basic structure doctrine, the beginning of the basic structure doctrine was this. Okay? Now, Government of India was committed towards the policy of land reforms, so it could have not, watched this happening, this particular incident silently. Now, in order to overrule and nullify the decision of Patna High Court, the Provisional Parliament, it enacted first Constitutional Amendment Act. First Constitutional Amendment Act in 1951. Remember, the first Constitutional Amendment Act was enacted by a provisional parliament. क्योंकि उस टाइम पे इलेक्शंस नहीं हुए थे. फर्स्ट इलेक्शंस वे कंडक्टेड इन 1951-52. उसके पहले ये अमेंडमेंट की गई थी. गवर्नमेंट ऑफ इंडिया डिड नॉट इवन वेट फॉर द डिसीजन ऑफ सुप्रीम कोर्ट in case of Kameshwar. See, this decision of Patna High Court was challenged in the Supreme Court by the government, but it did not wait for the decision of Supreme Court. It enacted first Constitutional Amendment Act 1951. What was the purpose of enacting the first Constitutional Amendment Act 1951? To protect the policy of land reforms, to protect the land reform laws passed by various state legislatures from being challenged in the Supreme Court or High Court on the grounds of violation of fundamental rights, particularly right to private property. That was the purpose. So, first Constitutional Amendment Act 1951, along with inter alia, meaning along with other things, it added Article 31A, Article 31B, and 9th schedule in the Indian Constitution. First Constitutional Amendment Act 1951 dealt with many things, but we are discussing only those provisions which are important for this discussion. So, first Constitutional Amendment Act 1951, along with other things, it basically added 2 articles and 1 schedule, Article 31A, Article 31B, and 9th schedule of the Indian Constitution. Now, Article 31B is very, very important for our discussion. Now, Article 31B saves the acts and regulations passed by the Parliament and state legislature and inserted in the 9th schedule from being challenged in the Supreme Court or High Court on the grounds of violation of the fundamental rights. So it means that the moment Parliament inserts any law in the 9th schedule, that particular law cannot be challenged in the Supreme Court or High Court on the grounds of violation of fundamental rights. That is what the article, because Article 31B protects, saves the laws and regulations passed by the Parliament as well as state legislatures and which are inserted in 9th schedule from being challenged in the court on the grounds of violation of fundamental rights. इन्होंने क्या किया? The first Constitutional Amendment Act 1951, it inserted 13 land reform laws passed by various state legislatures in the 9th schedule, including the Bihar Land Reforms Act 1950. It put these 13 land reform laws in 9th schedule. So according to Article 31B, these land reform laws cannot be challenged in the court on the grounds of violation of fundamental rights because they kept it in the 9th schedule. That is what 9th schedule is all about. I am going to discuss the amendability or the scope of judicial review of 9th schedule, but for this discussion, just remember this. Okay? Right? What is the first constitutional amendment? So first, the basic purpose of first Constitutional Amendment Act 1951 was to restrict the scope of right to private property, which was under original constitution fundamental right. Right? So basic purpose was to assist the state legislatures, right, to help them to pass various land reforms laws. Right? Okay? This was the response. Now, the constitutional validity of the first Constitutional Amendment Act 1951 was challenged in the Supreme Court of India in Shankari Prasad versus Union of India, 1951. Kameshwar Singh, 1950. First Constitutional Amendment Act, 1951. It was challenged in Shankari Prasad versus Union of India case, 1951. Obviously, landlords, they went to the Supreme Court, they said, oh, this first Constitutional Amendment Act is unconstitutional. Why? On the same grounds. They said that the first Constitutional Amendment Act restricted the scope of right to private property, and it is discriminatory, and that is why it violates Article 4. They say that the first Constitutional Amendment Act violates Article 14, Article 19, Clause 1, Subclause F, and Article 31. And hence, it should be declared, the first Constitutional Amendment Act should be declared as unconstitutional under Article 13, Clause 2. That is what was the argument of petitioners. ठीक है, समझ में आया? Now, Supreme Court of India in this Shankari Prasad case, it gave a very creative interpretation of the expression law under Article 13, Clause 2. Okay? Now, listen to me very carefully. Supreme Court argued that under the Constitution, Parliament enjoys two types of legislative or law-making powers. First, constituent legislative power. Constituent legislative power under Article 368. And second, ordinary legislative power outside Article 368. Right? Supreme Court said that under the Constitution, Parliament enjoys two types of legislative powers or law-making power. One is constituent legislative power under Article 368 and ordinary legislative power outside outside Article 368 under other articles of the Indian Constitution. Right? So, Supreme Court said that the law-making power of the Parliament in exercise of constituent legislative power, right, is called as constituent legislative power. Meaning, law-making power of the Indian Constitution, law-making power of the Parliament under Article 368 is called as constituent legislative power. I repeat, law-making power of the Parliament under Article 368, it is called as constituent legislative power. And law-making power of the Parliament outside Article 368 is called as ordinary legislative power. So, Supreme Court said that Parliament enacts constitutional amendment acts in exercise of its constituent legislative power. So, any law or enactment passed by the Parliament in exercise of its constituent legislative power is called as constitutional amendment acts. Right? Any enactment or any law passed by the Parliament in exercise of its constituent legislative power is called as constitutional amendment act. And any enactment or law passed by the Parliament in exercise of its ordinary legislative power, they are called as ordinary laws. Got it? Okay? So, under Article 368, if Parliament passes any law, then that law will be called as constitutional amendment law or constitutional law. Right? And all the laws passed by the Parliament outside Article 368, they will be called as ordinary laws. Now, Supreme Court basically said that the ordinary legislative power and the constituent legislative power, they are totally different. Supreme Court said that there is a clear-cut demarcation between the constituent legislative power of the Parliament under Article 368 and ordinary legislative power outside Article 368. There is a clear-cut difference between constitutional amendment acts and ordinary laws. It argued that ordinary laws are passed by only simple majority and Constitutional Amendment Acts are passed by special majority. They are not one and the same, right? They said that Constitutional Amendment Acts are different from ordinary laws. Why? Because Constitutional Amendment Acts are passed by the Parliament in exercise of its constituent legislative power available under Article 368. And ordinary laws are passed by the Parliament in exercise of its ordinary legislative power, which is outside Article 368, and that is why Constitutional Amendment Acts and ordinary laws, they are different from each other. So Supreme Court basically said that there is a clear-cut demarcation between Constitutional Amendment Acts and ordinary laws, and hence it said that expression law under Article 13 Clause 2 only includes ordinary laws passed by the Parliament and state legislature. The expression law under Article 13 Clause 2 does not include Constitutional Amendment Acts passed by the Parliament under Article 368 in exercise of its constituent legislative power. सुप्रीम कोर्ट ने कहा कि आर्टिकल 13 क्लॉज 2 में जो ये वर्ड लॉ है ना, द वर्ड लॉ इंक्लूड्स ओनली ऑर्डिनरी लॉज passed by the Parliament or the state legislature in exercise of their ordinary legislative power. Meaning to say, in other words, Supreme Court in Shankari Prasad argued that Constitutional Amendment Acts, they do not come within the ambit or purview of Article 13 Clause 2. The Constitutional Amendment Acts, they do not come under the expression law, meaning they are not limited, they are not they cannot be. So it means that Supreme Court said that Constitutional Amendment Act, they are not within the purview or ambit of Article 13 Clause 2. What is Article 13 Clause 2? State shall not make any law. Now the expression law only means ordinary laws. It does not include Constitutional Amendment Acts, and that is why Supreme Court argued that if any Constitutional Amendment Act passed by the Parliament that takes away or abridges fundamental rights, then that cannot be declared as null and void. Why? Because the Constitutional Amendment Acts, they do not come under the purview of Article 13 Clause 2. Article 13 Clause 2 applies only, this limitation applies only to the ordinary laws and not to the Constitutional Amendment Acts. So in other words, in Shankari Prasad, Supreme Court of India held that under Article 368, Parliament has power to amend the Constitution, including the fundamental rights. So Supreme Court said that Parliament, by passing Constitutional Amendment Acts under Article 368, can take away or abridge the fundamental rights conferred by Part 3 of the Indian Constitution. So Supreme Court said that Parliament has power to amend the Constitution, including the fundamental rights. Parliament under Article 368 can pass Constitutional Amendment Act and take away your fundamental rights. And such Constitutional Amendment Acts will not be declared as null and void under Article 13 Clause 2. Why? Because expression law under Article 13 Clause 2 includes only ordinary laws, not Constitutional Amendment Acts. Got it? And that is why Supreme Court upheld the constitutional validity of first Constitutional Amendment Act 1951. Got it? Okay, because in Shankari Prasad case, the constitutional validity of first Constitutional Amendment Act was challenged. So in Shankari Prasad, Supreme Court basically gave a very creative interpretation of the Constitution. And it said, it made a very clear-cut distinction or demarcation between Constitutional Amendment Acts and ordinary laws. And it also basically empowered the Parliament to amend the fundamental rights. Okay? And the problem was solved. That is what government wanted. Now, Supreme Court upheld this line of argument in number of judgments from Shankari Prasad till Sajjan Singh versus State of Rajasthan. 1965. The same argument was upheld or given by the Supreme Court in number of cases from Shankari Prasad 1951 till Sajjan Singh versus State of Rajasthan 1965. And thereby it upheld the constitutional validity of 4th Constitutional Amendment Act, which inserted 7 laws in 9th schedule, right, by giving the same argument, right? Okay? 7th Constitutional Amendment Act, 4th Constitutional Amendment Act, so on and so forth. Okay? From Shankari Prasad to Sajjan Singh. Now why? Why Supreme Court of India basically empowered the Parliament to amend the fundamental rights and take away the fundamental rights of the citizens? You know why? Because for the first 17 years after independence, the Supreme Court reposed the faith in the wisdom of political leadership and Parliament of India. It trusted the political leadership of that time. Why? Because most of the political leaders or most of the members of Parliament at that time were, they were freedom fighters. And they were men of utmost integrity, right? And that is why Supreme Court reposed faith in the Parliament and in the faith and wisdom of the political leadership at that time. But what happened? The Constitution of India was basically kept, the political leadership, it kept on amending the Constitution to suit the will of the ruling dispensation. So Constitution kept on being amended just to suit the political class of that time or just to suit the government. So that is why Supreme Court of India decided to apply some brakes on the power of Parliament to amend the Constitution. And that brake was applied by the Supreme Court of India in another landmark case called as Golaknath. Golaknath versus State of Punjab. 1967, don't forget the year. So Supreme Court in Keshavananda Bharati case made this judgment basic structure should not be amended. No, that is not the basic structure should not be amended. Nahi, ऐसा नहीं है. I am coming to the Keshavananda Bharati case. Golaknath. Golaknath, इसका actual name है I.C. Golaknath and others versus State of Punjab and others. Do not write Union of India. You cannot make factual mistakes in writing the name of the case, right? Then examiner will cut your marks. Okay, right? Now this was another landmark case. In Golaknath versus State of Punjab, case of 1967, the constitutional validity of 17th Constitutional Amendment Act 1964 was challenged. Okay, right? In Shankari Prasad, the constitutional validity of 1st Constitutional Amendment Act was challenged, 1951. In Golaknath case, constitutional validity of 17th Constitutional Amendment Act was challenged. Now the 17th Constitutional Amendment Act, what it did? It was also about protecting the land reform laws passed by the state legislatures. The 17th Constitutional Amendment Act 1964 inserted 44 land reform laws passed by various state legislature in 9th schedule of Indian Constitution and thereby protected them from the judicial review. Even if they violated the fundamental rights. So they cannot be challenged. Right? समझ में आया 17th Constitutional Amendment Act क्या था? ठीक है? It inserted 44 land reform laws in 9th schedule. And that is why the constitutional validity of 17th Constitutional Amendment Act 1964 was challenged in Golaknath versus State of Punjab 1967. Now this was the 11 judge bench. It was the largest ever bench constituted by Supreme Court of India at that time. And the judgment was given by slender majority, that is 6:5. Now, what does Supreme Court argue or upheld in Golaknath case? Golaknath versus State of Punjab 1967. Now, first of all, Supreme Court overruled its earlier judgments, right from Sajjan Singh to, right from Shankari Prasad till Sajjan Singh. It overruled its own judgments from Shankari Prasad till Sajjan Singh. Now, Supreme Court argued that under the Constitution, Parliament enjoys only one type of legislative power, that is ordinary legislative power. Ordinary legislative power. It is really interesting. Supreme Court in Golaknath case argued that under the Constitution, Parliament enjoys only one type of legislative power, that is ordinary legislative power, meaning Parliament under Constitution does not enjoy constituent legislative power. Which was held by Supreme Court from Shankari Prasad till Sajjan Singh. So Supreme Court overruled its own judgments, earlier judgments from Shankari Prasad till Sajjan Singh, and it said that no. Under the Constitution, Parliament enjoys only ordinary legislative power. It can make only ordinary laws. Under the Constitution, Parliament does not have any power to amend the Constitution. It does not have any constituent legislative power. I told you that law made by the Parliament in exercise of constituent legislative power, such law is called as Constitutional Amendment Act. So it means that Supreme Court argued that Parliament cannot amend the Constitution of India under Article 368, including the fundamental rights. Supreme Court said that Parliament does not have constituent legislative power, and hence Parliament cannot amend the Constitution, including the fundamental rights. Parliament does not have power to amend the fundamental rights, because it said that even the Constitutional Amendment Acts will be called as ordinary laws, because so Supreme Court, unlike in Sajjan case, did not make a clear-cut distinction between Constitutional Amendment Acts and ordinary laws. So it said that the expression law under Article 13 Clause 2 also includes Constitutional Amendment Acts. The expression law under Article 13 Clause 2 also includes Constitutional Amendment Acts. And that is why if any constitutional amendment violates or takes away or abrogates any of the fundamental rights conferred by Part 3, then such constitutional amendment, to the extent of such contravention of fundamental rights, will be declared as null and void, according to Article 13 Clause 2. Now, what was the basis of this argument? Now, Supreme Court in this Golaknath case basically took a very verbatim or a narrow or literal interpretation of Article 368. Now see, under the original Indian Constitution, the title of Article 368 was Procedure to Amend the Constitution. Originally, Article 368 was titled as Procedure to Amend the Constitution. So Supreme Court argued that, look at Article 368, the title of Article 368. It argued that if you look at the title of Article 368, it merely contains the procedure to amend the Constitution. It does not confer any power on the Parliament to amend the Constitution. It only contains the procedure to amend the Constitution. It does not empowers the Parliament to amend the Constitution. And that is why it said that Parliament does not have any power to amend the Constitution, including fundamental rights, under Article 368. So it basically had a very verbatim or a narrow interpretation of Article 368. Verbatim, जैसे लिखा है, बोलो देखो ये क्या लिखा हुआ है, प्रोसीजर है ना, पावर तो नहीं है, कहाँ पावर लिखा हुआ है. So Article 368 nowhere empowers the parliament. It nowhere confers the power to the parliament to amend the constitution. Right? This was the first argument. No distinction between, it said that under the constitution, parliament enjoys only one type of legislative power, that is ordinary legislative power. So no demarcation, no distinction between ordinary legislative power and constituent legislative power. Parliament does not have any constituent legislative power. Why? Because Article 368 only contains the procedure to amend the constitution. This was the first argument. Okay? Second, Supreme Court basically in Golaknath case gave one of the best defense of fundamental rights of the citizens. Right? Supreme Court in Golaknath case argued that fundamental rights, basically they occupy unique position in the life of civilized societies like India. It argued that fundamental rights are transcendental and immutable. Transcendental meaning something which is of an extreme importance, which is special. Right? Okay? It argued that fundamental rights are transcendental. They are immutable. Immutable means they cannot be changed. They are sacrosanct. Meaning too pious, too important to be changed. They are sacrosanct. Right? Okay? They are inalienable. Fundamental rights are inalienable. They cannot be taken away by the state. It argued that fundamental rights are primordial rights. Primordial rights. Fundamental rights are primordial rights, meaning rights which are enjoyed by the citizens since the beginning. Since the beginning, since the time immemorial. The citizens, they enjoy the fundamental rights. Such that these are primordial rights. Supreme Court argued that fundamental rights are essential for fullest development of human personality. Fundamental rights are essential for individuals to attain their fullest potential. And that is why they cannot be amended by a majority in the parliament. No. It said that the parliament, by using its brute majority, cannot take away and abridge the fundamental rights of the citizens. Why? Because they are transcendental, they are immutable, they are sacrosanct, they are inalienable, and they are primordial rights which exist since the beginning. It argued that fundamental rights are not given by the parliament or by the state. People, individuals, they enjoy the fundamental rights just because they are human beings, right? That is what Supreme Court defended the fundamental rights. And that is why I told you it was one of the best defense of fundamental rights of the citizens. Okay? Now, to sum up, what was the argument of the Supreme Court in Golaknath versus State of Punjab? It said that Parliament does not have any power to amend the constitution, including the fundamental rights. In Shankari Prasad case, it was opposite. Shankari Prasad case, Supreme Court said that Parliament has power to amend the constitution, including fundamental rights under Article 368. Okay? Now, the question was, then how to amend the constitution then? How the constitution can be amended? Supreme Court said that to amend the constitution, you need to reconvene the Constituent Assembly. If you want to amend, if government wants to amend the constitution, it has to reconvene the Constituent Assembly which framed Indian Constitution. Now, it was a very, very surprising argument. See, the judgment was given in 1967. Now, by the 1967, most of the members of Constituent Assembly, they were not alive. So, how can you reconvene the Constituent Assembly? So, it meant that reconvening of Constituent Assembly was not possible. So, it meant that Constitution cannot be amended. So that is why the Golaknath judgment was very retrograde judgment. Retrograde, backward looking. To some extent. Why retrograde? Why backward looking? Why it was a narrow judgment? Why? Because it basically took away the dynamism of the Indian constitution. It made the constitution static by not allowing the parliament to amend the constitution. And I told you that constitution is a living organic document. Like organism, it evolves continuously. You cannot make constitution static. Constitution cannot be a final word on everything. Constitution must be able to adapt itself to the changing needs of times and circumstances. It should be dynamic. Constitution should be dynamic. But Golaknath said that parliament cannot amend the constitution. If you want to amend the constitution, you have to reconvene Constituent Assembly. Constituent Assembly cannot be reconvened. Most of the members were dead. So it basically made the constitution static. It took away the dynamism of the constitution and made a constitution static and a dead document. Anything which is a static, that is a dead, that cannot grow. And that is why in this aspect, the Golaknath judgment was retrograde. It was backward looking judgment. And what about article? Now the second thing was about interpretation of title of Article 368. Now, if Constituent Assembly or founding fathers of the Constitution did not want to confer the power to the Parliament to amend the Constitution, then why would they have included the Article 368 itself? अगर उन्होंने पावर ये वर्ड रेफर मेंशन नहीं किया है, लेकिन अगर वो ये करना चाहते थे कि पार्लियामेंट को पावर ही नहीं है अमेंडमेंट करने का, तो ये आर्टिकल 368 ही क्यों ऐड करते? Why they would have provided for procedure to amend the constitution if they wanted to take away the power, if they wanted parliament not to have any power to amend the constitution. If you look at Article 368, it provides procedure in such a detail. So the very fact that founding fathers of the Indian Constitution incorporated Article 368, it meant that they wanted the Parliament to have this power of amending the Constitution. But Golaknath case, Supreme Court took only literal or verbatim or a narrow interpretation of Article 368. Right? Okay, so this is what was the Golaknath judgment. Now the Golaknath judgment was a setback to the government. Obviously it was a setback. So that was a tussle between parliament and judiciary. That started a tussle between parliament and judiciary. From Shankari Prasad till Sajjan Singh, Supreme Court and parliament, they cooperated with each other. But in Golaknath case, Supreme Court and parliament, they directly came at the confrontation level. The tussle, they started a tussle between parliament and the legislature and the Supreme Court. And same thing happened in Kameshwar Prasad Singh versus province of Bihar, right? Patna High Court, government. So what would have government done? Obviously, government would have not be a silent spectator to the Golaknath case, right? Now, in order to overrule the Golaknath judgment, in order to overrule the judgment of Supreme Court in Golaknath versus State of Punjab 1967, Parliament of India enacted 24th Constitutional Amendment Act in 1971. Golaknath judgment was given in 1967. In 1977, since 1967, Indira Gandhi was at the helm of affairs. And you know the personality of Indira Gandhi. How could have she accepted the limitations on the power of parliament, effectively the government, to amend the constitution? So, parliament responded to the Golaknath judgment by enacting 24th Constitutional Amendment Act 1971. Now, this 24th Constitutional Amendment Act 1971 did following changes to the constitution. Number one, it added new clause 4 in Article 368, meaning it added 368 clause 4 in the constitution. Okay, right? Oh, sorry. Before this, very important. Number one, first, it changed the title of Article 368. सुप्रीम कोर्ट ने क्या बोला कि आर्टिकल 368 का जो टाइटल है it merely states that procedure to amend the constitution. So the title of Article 368 was changed from procedure to amend the constitution to power of parliament to amend the constitution and procedure therefore. I told you in the beginning. What was the original title? Original title was procedure to amend the constitution. So the title and in Golaknath case, Supreme Court interpreted the Article 368 in a very narrow lens, through narrow lens. It was a verbatim interpretation. So that is why first thing 24th Constitutional Amendment Act 1971 did was to change the title of Article 368 from procedure to amend the constitution to power of parliament to amend the constitution and procedure therefore. So it explicitly mentioned or it empowered the parliament to amend the constitution, right? Number one. Okay. Number second, it added new clause. It added clause 4 in Article 368. Meaning it added Article 368 clause 4. Original Article 368 had only 3 clauses. So 24th Constitutional Amendment Act added new clause. Clause 4. Okay? Now clause 4 stated that nothing in Article 13 shall apply or shall be applicable to, shall apply to any amendments made to the Indian Constitution, any amendment made under this article, that is Article 368. It stated that nothing in Article 13 shall apply to any amendment made under Article 368. Meaning Article 368 clause 4 excluded the constitutional amendment acts enacted under Article 368 from the definition of law or from the expression law. It said that constitutional amendment acts passed by the parliament under Article 368 will not be included in the expression law under Article 13. Right? Okay? Second, it also included, third, it also inserted new clause 13 clause 4. Make change Article 368.3. Article 368.3, not 4. So original Article 368 had only 2 clauses. Please make change. Did I tell you 3 or 4? So please make it change 3. Article 368.3. ठीक है, make change. किया? Change किया? किया ही नहीं किया? पहले clause दूसरा क्या था? दूसरा added new clause 3 in Article 368. ठीक है? तो मैंने ये clause 4 बोला है, तो that is wrong. Clause 3 in Article 368. ठीक है? Right? Sorry for that mistake. It was a big mistake. Anyways, because there is a confusion, no? यहाँ पे Article 13 में 4 किया है, 368 में, ठीक है? तो that is why I got confused, but you don't get confused. Now you realize. Okay. Then, so it changed the title of Article 368. It added new clause in Article 368, that is clause 3. Then it added new clause in Article 13, that is clause 4, 13 clause 4. Okay? Originally, Article 13 had only 3 clauses. Clause 1, Clause 2, Clause 3. Clause 4 was added through 24th Constitutional Amendment Act 1971. Okay? Originally, Article 368 had only 2 clauses. Clause 3 in Article 368 was added through 24th Constitutional Amendment Act 1971. Clear? Clear? Very good. Now, what does Article 13 Clause 4 states? It states that nothing in this article, that is Article 13, nothing in this article shall apply to any amendment made to the Constitution under Article 368. Nothing in this article, that is Article 13, shall be applicable to any amendment made to the Constitution under Article 368. Meaning it also excluded itself. Article 13 itself excluded Constitutional Amendment Act from the expression law. So meaning both Article 368 Clause 3 and Article 13 Clause 4 did the same thing. That is excluding the Constitutional Amendment Act from the purview of Article 13. To be precise, Article 13 Clause 2. Meaning Constitutional Amendment Acts, they are not within the, they were kept beyond the purview of Article 13. This is what, right? Along with this, it also did one more thing, but that is not important from this particular discussion. But just remember, 24th Constitutional Amendment Act 1971 also made it mandatory for the President to give his assent to the constitutional amendment bills. Remember our discussion on types of majorities? It was 24. It was this amendment, 24th Constitutional Amendment Act 1971, right? So 24th Constitutional Amendment Act 1971 basically was enacted to overrule the judgment of Supreme Court in Golaknath versus State of Punjab. What did Supreme Court say? The expression law includes Constitutional Amendment Acts. And it said Parliament does not have any power to amend the Constitution. Why? Because the title. So first, the title was changed. Second, it was explicitly mentioned that the expression law under Article 13 will not include Constitutional Amendment Acts. Constitutional Amendment Acts passed by the Parliament under Article 368 are outside the ambit of Article 13. Meaning, if Parliament passes any Constitutional Amendment Acts which takes away or abrogates any of the fundamental rights, then they cannot be challenged. Parliament has, meaning Parliament. So, the 24th Constitutional Amendment Act 1971 restored the power of the Parliament to amend the Constitution, including the fundamental rights, which was taken away by Golaknath. Got it? Clear? Okay? Fine. Now, the constitutional validity, so if you look at the 24th Constitutional Amendment Act 1971, the 24th Constitutional Amendment Act 1971 did not do anything new, because this is what was held by the Supreme Court from Shankari Prasad till Sajjan Singh case. Right? So 24th Constitutional Amendment Act 1971 only gave constitutional status to judicial decisions from Shankari Prasad till Sajjan Singh. Because even in Shankari Prasad till Sajjan Singh, Supreme Court held that the expression law does not contain the Constitutional Amendment Act. So what was implicit, what was indirect, was made explicit through 24th Constitutional Amendment Act 1971. The judicial decisions of the Supreme Court from Shankari Prasad till Sajjan Singh versus State of Rajasthan case of 1965 were given constitutional status through 24th Constitutional Amendment Act 1971. Got it? Okay? Fine. Now the constitutional validity of 24th Constitutional Amendment Act, right, was challenged. The constitutional validity of 24th Constitutional Amendment Act 1971 was challenged in a landmark and historic case, Kesavanand Bharati versus State of Kerala. along with other things, the inter alia means along with other things, the constitutional validity of 24th Constitutional Amendment Act 1971 was challenged in case 1 and the Bharati case. Why I said along with? Because even the constitutional validity of other constitutional amendment acts was challenged in this case. But for our discussion, let us restrict our discussion to the 24th Constitutional Amendment Act. Okay? Now, the case 1 and the Bharati judgment was decided by 13 judge bench. Golaknath was decided by 11 judge bench. The case 1 and the Bharati case was decided by 13 judge bench. And till date, this was the largest ever bench constituted by the Supreme Court. ठीक है, अभी तक का सबसे बड़ा अगर कोई बेंच होगा सुप्रीम कोर्ट का तो वो ये था, 13 judge bench. And the decision was again given by slender majority, 7:6. 7 judges versus 6 judges, slender majority. Now, what did case 1 and the Bharati case, what did Supreme Court rule in this case? Number 1, Supreme Court in case 1 and the Bharati case overruled its judgment in Golaknath case. Number 2, it upheld the constitutional validity of 24th Constitutional Amendment Act 1970. It overruled its own earlier judgment in Golaknath case, Golaknath versus State of Punjab 1967, and second, it upheld the constitutional validity of 24th Constitutional Amendment Act 1971. Okay? Now, what was the argument given by Supreme Court? Now, Supreme Court argued that under the Constitution, Parliament enjoys both constituent legislative power under Article 368 and ordinary legislative power under outside Article 368. Golaknath said no, Parliament enjoys only one type of legislative power. So the argument given by Supreme Court in Shankari Prasad was repeated in Kesavananda Bharati as well. Supreme Court said that yes, under the Constitution, Parliament enjoys constituent legislative power under Article 368 and ordinary legislative power outside Article 368, and it said that the expression law under Article 13 Clause 2 includes only ordinary laws which are made by the Parliament in exercise of its ordinary legislative power. Supreme Court ruled that the expression law under Article 13 does not include constitutional amendment acts passed by the Parliament in exercise of its constituent legislative power under Article 368. Clear? Okay, fine. So that is why Supreme Court said that Parliament has power to amend the Constitution, including any of the fundamental rights. Okay? Now, unlike before, right? Unlike in other cases before case 1 and the Bharati case, see, before case 1 and the Bharati case, Supreme Court of India only encountered one question. It dealt with only one question. Number 1, whether Parliament has power to amend the Constitution, including fundamental rights or not. So in case 1 and the Bharati case, Supreme Court said in affirmation, said yes, Parliament has power to amend the Constitution, including fundamental rights. This was the question which was dealt with Supreme Court, dealt by the Supreme Court before the case 1 and the Bharati case. But case 1 and the Bharati case was different. In case 1 and the Bharati case, Supreme Court not only dealt with one issue but two issues. One was whether the Parliament has power to amend the Constitution, including fundamental rights or not. It said yes, Parliament has power to amend the Constitution, including fundamental rights. Number 1, right? Second question which Supreme Court encountered was whether the power of Parliament to amend the Constitution unlimited and unfettered. Whether this power, ठीक है, पहला क्वेश्चन क्या है, whether Parliament has power to amend the Constitution, including fundamental rights or not. In this case, the second question was answered by the Supreme Court was that whether the Parliament's power to amend the Constitution under Article 368, whether it is limited or unlimited. This was the second question which was answered by the Supreme Court. Now, Supreme Court argued that under the Constitution, Parliament enjoys only limited power. Under the Constitution, Parliament enjoys only limited power to amend the Constitution. It argued that power of Parliament to amend the Constitution under Article 368, they are not unlimited. They are not unfettered. Right? Okay? Now, to what extent it is limited? And herein Supreme Court gave the doctrine of basic structure. Supreme Court argued that, number one, power of Parliament to amend the Indian Constitution is limited to the extent of not violating or destroying or taking away what it called as basic structure. Basic structure of the Indian Constitution. Power of the Parliament to amend the Constitution under Article 368 is subject to the limitation of not violating, not destroying what it called as basic structure of the Indian Constitution. So Parliament can amend any part of the Indian Constitution, including fundamental rights, under Article 368, but such constitutional amendment acts passed by the Parliament under Article 368 shall not destroy, shall not violate what it called as basic structure of the Indian Constitution. Now, what was the argument given by Supreme Court in this regard? Very interesting. Now, Supreme Court, it argued that there is a difference between constituent power of, number one, Constituent Assembly, and number two, Parliament. Supreme Court argued that there is a difference. There is a difference between constituent power of Constituent Assembly and constituent power of Parliament. It argued that the Constituent Assembly enjoyed original constituent power. Constituent Assembly of India enjoyed original constituent power with which it enacted the Constitution. The Constitution of India enjoyed original constituent power. Why? Because it was not limited by any pre-existing constitution as such. So Constituent Assembly had unlimited constituent powers. It enjoyed original constituent power. But Supreme Court argued that Parliament's constituent power, Parliament enjoys, or Parliament's constituent power under Article 368 is derivative power. It's derivative constituent power. Derivative constituent power. Why it is derivative constituent power? Because it is derived from the Constitution. So Parliament's power to amend the Constitution is limited by the Constitution, because it is not original. Parliament does not enjoy original constituent power. The original constituent power was enjoyed by the Constituent Assembly, with which it enacted the Indian Constitution. So Constituent Assembly, the powers of Constituent Assembly were not limited by any pre-existing constitution. But the constituent power of the Parliament is derivative constituent power, not original constituent power. The power of the Parliament, the constituent power of the Parliament is derived from the Constitution itself. So the power of Parliament to amend the Constitution cannot be exercised unlimited, because it is not original constituent power. It is a derivative constituent power, and that is why Parliament has power to amend the Constitution, but it cannot destroy or take away what it called as basic structure of the Indian Constitution. Now, what is basic structure? What is basic structure? What is base? What is base? Base is a foundation. The word basic means base or a foundation on which structure is built. So Supreme Court argued that Constitution of India is built on a base or a foundation, And if that base or foundation is taken away or disturbed, then the entire structure of the constitution will collapse. Now, Supreme Court argued that there are certain features of the constitution, there are certain provisions of the constitution which are very essential. There are certain provisions of the constitution which are basic features, which are essential features. Without these features, if you take away these features, then the constitution will lose its identity, its character, and its spirit. So Supreme Court argued that the basic structure of doctrine include all those provisions of Indian Constitution which provides identity to the Constitution, or from which the Constitution derives its character or spirit. And if you take away that spirit, the Constitution will be dead. So basic structure, according to Supreme Court of India, meant such essential features of the Constitution without which Constitution will lose its character, its identity, and its spirit. Basic structure doctrine includes those foundational principles and values without which Constitution will lose its character. Right? So basic structure includes those foundational principles and values upon which the Constitution is based. Now, Supreme Court of India did not explicitly mention what are the provisions of the Constitution which are part of basic structure. It did not give a direct list. Okay, ye list hai, ye basic structure. No. Supreme Court of India, from Kesavananda Bharati case till date, in various judgments, said that I have given the judgments about what are the provisions of the Constitution. They are part of basic structure. Right? Okay. What constitutes basic structure is decided by the Supreme Court of India from case to case basis. Okay, right? But Supreme Court of India in various cases has upheld or has said that following provisions of the Constitution, they are part of basic structure. Write down. One is supremacy of the Constitution. Supremacy of Constitution. See, in Kesavananda Bharati case, Supreme Court did not give the list of what constitute the basic structure of the Indian Constitution. Okay? Right? So Supreme Court decides the components of basic structure of the Indian Constitution from case to case basis. Supremacy of the Constitution. Sovereignty of India. Mandate to build welfare state. Separation of powers between different branches of government. Democratic, republic, and parliamentary form of government. Okay, write down quickly. Balance between fundamental rights and directive principles of state policy. Write down quickly. There is no time. Chalo, likho. Supremacy of the Constitution. Sovereignty of India. Democratic, republican and parliamentary form of government. Mandate to build welfare state. Balance between fundamental rights and directive principles of state policy. Balance between different organs of the government. Fundamental rights under Article 14, 15, 19, 21. These are also part of basic structure. Can we say that preamble is a source of basic structure? Not the entire, remember whoever asked this question, entire preamble is not a part of basic structure of the Indian Constitution. If entire preamble would be the part of basic structure, then preamble would have not been amended, but preamble was amended in 1976, 42nd Constitutional Amendment Act. So the entire preamble is not a part of basic structure, but the values and principles contained within the preamble, they are part of basic structure and not the entire preamble. And that is why preamble can be amended. If you say that preamble is a part of basic structure, then you cannot amend the preamble. But Supreme Court in Kesavananda Bharati case itself said that preamble can be amended. Okay? Fine. Anyways, So judicial review next. Judicial review, independence of judiciary. These are also part of basic structure. Secularism, federalism, etc. All these are part of basic structure of the Indian Constitution. Okay? So Supreme Court in Kesavananda Bharati case, it argued that the Constitution of India is not merely a political document. It is a social document. It is a social document based on social philosophy. And like any philosophy, like religion, Constitution also has some principles which are core principles, and some principles which are not core, right? So those principles of the Constitution which are core, they cannot be disturbed, they cannot be taken away, right? So it argued that Constitution is not merely a political document, it is a social document which has social philosophy. So it argued that Parliament cannot, by using majority, government cannot, by using the majority in the Parliament, can destroy the essence of the Constitution, the soul of the Constitution or spirit of the Constitution. So basic structure of the Indian Constitution is the very soul of the Indian Constitution. There are certain essential principles and values of the Indian Constitution which gives its unique character, identity. These principles, these are all, I told you, rule of law is also a part of basic structure. Separation of power, these are all fundamental values without which Constitution will be uprooted. Constitution will lose its relevance. So Supreme Court ने इस केस में कहा कि Parliament has power to amend the Constitution, including the fundamental rights under Article 368, but Parliament's power to amend the Constitution is limited to the extent of not violating or destroying basic structure of the Indian Constitution, right? And Supreme Court till date has not, there is no clarity as to which is a part of basic structure. Supreme Court interprets this from case to case basis. So in Kesavananda Bharati case, Supreme Court said separation of powers is a part of basic structure, for example. So from case to case basis, the elements of basic structure have been decided by the Supreme Court, right? Now Supreme Court in Kesavananda Bharati case basically did two things. Number one, it upheld the power of the Parliament to amend the Constitution, and that is why it protected the dynamism within the of the Constitution by allowing the Parliament to amend the Constitution in accordance with the changing needs of times and circumstances. So it protected the dynamism of the Constitution, which was taken away by the Golaknath case, right? Second, right? So first was that it protected the dynamism of the Constitution. Okay. Second, by limiting the power of the Parliament to amend the Constitution, okay, the Supreme Court maintained the constitutional balance. Between the different branches of government. See, Golaknath case disturbed the constitutional balance in favor of judiciary by saying that Parliament cannot amend the Constitution, right? So Kesavananda Bharati ke judgment was a fine balancing act. It was a fine balancing act. This judgment was a fine balancing act. So on one hand, it upheld the power of the Parliament to amend the Constitution, including the fundamental rights under Article 368. But on the other hand, by giving the doctrine of basic structure, it said that power of the Parliament to amend the Constitution is limited, and thereby it protected the constitutional balance. It was a wonderful, that's why it is a historic and landmark judgment. Okay? So to sum up, Supreme Court of India said that Parliament under Article 368 has power to amend the Constitution, including the fundamental rights. Okay? But that power to amend the Constitution is limited to the extent of not violating the basic structure of the Indian Constitution. So in the beginning, I told you about subject matter of basic structure doctrine. That is, what is the scope and extent of power of Parliament to amend the constitution, including the fundamental rights under Article 368. Now you got the answer. The scope and extent. So Parliament of India has power to amend the constitution, including Article 368, including fundamental rights under Article 368, subject to not violating the basic structure of the Indian constitution. Got it? Clear? Now, again, Government of India thought Kesavananda Bharati case as a threat, or it did not take it well, because it limited the power of Parliament to amend the constitution by giving this theory of basic structure, which is nowhere mentioned in the constitution. Right? So, Government of India responded by enacting 42nd Constitutional Amendment Act 1976. So, cat and mouse, game of cat and mouse. जजमेंट जुडिशरी कुछ जजमेंट दे रहा है, फिर पार्लियामेंट उसको ओवररूल करने के लिए. So 42nd Constitutional Amendment Act 1976 was enacted by the Parliament to overrule the judgment of Supreme Court in Kesavananda Bharati case. Now what did 42nd Constitutional Amendment Act did? 42nd Constitutional Amendment Act added new clause to Article 368, that is clause 4. It also added new clause to Article 368, that is clause 5. 42nd Constitutional Amendment Act 1976 added clause 4 and clause 5 in the Article 368. Article 368 clause 3 was added by 24th Constitutional Amendment Act 1971. So UPSC में prelims में question आ सकता है, क्योंकि ये basic structure doctrine से related है. So you don't have to remember this. If you know the basic structure doctrine, you will be able to answer. Right? ठीक है? Now what is Article 368 clause 4 provided? Article 368 clause 4 provided that the constitutional amendment acts passed by the Parliament under Article 368, they cannot be challenged in any court of law. Meaning Article 368 clause 4 kept the constitutional amendment acts passed by Parliament under Article 368 beyond the purview, beyond the ambit of judicial review. Meaning according to this Article 368(4), which was added by 42nd Amendment 1976, if Parliament passes any constitutional amendment acts under Article 368, they cannot be challenged in any court of law, including Supreme Court. So Article 368 clause 4 excluded the judicial review of constitutional amendment acts under Article 368. It put the constitutional amendment acts passed by the Parliament under Article 368 beyond the ambit, beyond the purview of judicial review. ठीक है? Fine. Then Article 368 clause 5, it explicitly mentioned that, this Article 368 clause 5 explicitly stated that there are no limitation whatsoever on the power of Parliament to amend the Constitution under Article 368. In Kesavananda Bharati case, Supreme Court said that power of Parliament to amend the Constitution are limited, subject to not violating or destroying the basic structure. Article 368 clause 5 provided that there are no limitations whatsoever on power of Parliament to amend the Constitution under Article 368. That is what Article 368 clause 5 is. So it means that 42nd Constitutional Amendment Act 1976 overruled, nullified the Supreme Court's judgment in Kesavananda Bharati case. Now, the constitutional, now this was a very retrograde amendment, 42nd Amendment 1976, which was passed during the national emergency by Indira Gandhi government. It was a very retrograde judgment. Why? Because it empowered the Parliament too much. It is as if Parliament by a special majority can transform the India from secular to Hindu Rashtra, and it cannot, that amendment cannot be challenged in the court. So this 42nd Constitutional Amendment Act 1976 disturbed the constitutional balance in favor of Parliament, and it uprooted the power of, or it took away the power of judicial review from the Supreme Court. So obviously the constitutional validity of 42nd Constitutional Amendment Act would have been challenged. Yes. So the constitutional validity of 42nd Constitutional Amendment Act was challenged in the Supreme Court in Minerva Mills versus Union of India case of 1980. Okay? The constitutional validity of 42nd Constitutional Amendment Act was challenged in Minerva Mills versus Union of India case 1980. Now, in this case, Supreme Court of India declared 42nd Constitutional Amendment Act 1976 as unconstitutional and void. Not the entire constitution, in the Minerva Mills versus Union of India case, Supreme Court of India declared those provisions of Indian Constitution which give unlimited power of Parliament to amend the Constitution. Meaning, in Minerva Mills versus Union of India case of 1980, Supreme Court declared Article 368 Clause 4 and Article 368 Clause 5 as unconstitutional and null and void. Not the entire 42nd Constitutional Amendment Act, because 42nd Constitutional Amendment Act is considered as a mini constitution. Okay? It also added for fundamental duties. तो पूरा कॉन्स्टिट्यूशनल अमेंडमेंट को डिक्लेयर नहीं किया गया नल एंड वॉइड. इट डिक्लेयर्ड आर्टिकल 368(4) and Article 368(5) as unconstitutional, null and void. Why? Because it argued that the Article 368 Clause 4 and 368 Clause 5, it violate or disturbs the basic structure of the Indian Constitution. Why? Because it takes away the power of judicial review. And Supreme Court in Minerva Mills case there said that the power of judicial review is a part of basic structure of the Indian Constitution. And if, what did Supreme Court in Kesavananda Bharati case said? If anything violates the basic structure of the Indian Constitution, then that will be declared as null and void. So, and then it also said that it disturbs the balance between two branches or between the branches of government. Why? Because Article 368 Clause 4 and 368(5) they basically tilted the constitutional balance completely in favor of the Parliament. So, Supreme Court in Minerva Mills versus Union of India case of 1980, it declared Article 368 Clause 4 and Article 368 Clause 5 as unconstitutional and null and void. Why? Because these two clauses violated, number one, the power of judicial review, and number second, it disturbed the balance between the various branches of government, and these are part of basic structure of the Indian. Judicial review is a part of basic structure of the Indian Constitution. Balance between branches of government, three branches of government, is also a part of basic structure of the Indian Constitution. And the Article 368 Clause 4 and 368(5), it violated the basic structure of the Indian Constitution. And that is why they were declared as null and void. This is what is the doctrine of basic structure. Okay? Now we started with Kameshwar Prasad Singh versus Province of Bihar, 1950. Then first Constitutional Amendment Act. Let me summarize this. So, याद रखना इसको. Kameshwar Singh वर्सेस प्रोविंस ऑफ बिहार. ये आपको शॉर्ट नोट बनाना है, ठीक है, 1950, ठीक है. फिर इसके नीचे क्या आएगा? फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1951, ठीक है. फिर इसके नीचे क्या आएगा? यस, शंकरी प्रसाद वर्सेस यूनियन ऑफ इंडिया. ये ऑलरेडी लिखा हुआ है ना आपने, तो पीछे जाओ. यूनियन ऑफ इंडिया 1951. ये लो, सब स्पून फीड चाहिए, सब कुछ दे दो सर हमको. ये लो, शंकरी प्रसाद, ठीक है, 1951. फिर उसके बाद में कहाँ आएंगे हम लोग? हाँ, शंकरी प्रसाद, सज्जन सिंह 1965, ठीक है. इसके बाद सीधे आएंगे हम लोग गोलकनाथ वर्सेस स्टेट ऑफ पंजाब 1967, ठीक है, ये ड्रॉप करना है याद रखने के लिए, ठीक है, बिकॉज इट्स नॉट दैट इजी, ठीक है। फिर गोलकनाथ के नीचे क्या आएगा, इसके नीचे क्या आएगा, 24th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1971, देन केशवानंद भारती केस वर्सेस स्टेट ऑफ केरला, कौन कहता है सोशल साइंस बहुत आसान है, हाँ। फिर केशवानंद भारती केस का रिस्पॉन्स क्या था, 42nd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1976। इसमें ब्रैकेट में आप लिख भी सकते हो क्या क्या ऐड किया, 368(4), 368 क्लॉज 5, यहाँ पे आप धीरे धीरे मतलब याद कर सकते हो। एंड देन लास्ट बट नॉट द लिस्ट, मिनर्वा मिल्स वर्सेस यूनियन ऑफ इंडिया 1980। And since Minerva Mills case, Supreme Court of India has used the doctrine of basic structure in order to look into the judicial review of constitutional amendment acts passed by the parliament. The last time Supreme Court of India used the doctrine of basic structure to declare the constitutional amendment act as unconstitutional and null and void was in 2015. In 2015. Supreme Court in 2015 declared 99th Constitutional Amendment Act 2014 and National Judicial Appointments Commission Act 2014. Both these, one was Constitutional Amendment Act, another was ordinary law. Supreme Court in 2015 declared this particularly 99 Constitutional Amendment Act 2014 as unconstitutional and void. Why? Because it violated what? It violated this Constitutional Amendment Act, 99 Constitutional Amendment Act and National Judicial Appointments Commission Act, both were enacted in 2014. They violated judicial review. Sorry, not judicial. They violated judicial independence by giving primacy to the executive over the appointment of judges. And it declared that judicial independence is a part of basic structure of the Indian Constitution. Now, since the 99 Constitutional Amendment Act and National Judicial Appointments Commission Act violated the judicial independence, which is a part of basic structure, by using the basic structure doctrine, it declared both these acts as unconstitutional, null and void. Right? This is an example. Now, even currently, the constitutional validity of 103rd Constitutional Amendment Act 2019, it has been challenged in the Supreme Court of India. 103rd Constitutional Amendment Act provided 10% reservation to economically weaker sections of society in government jobs and educational institutions. Now, the petitioners, they have challenged the constitutional validity of 103rd Constitutional Amendment Act 2019 on the grounds that it violates the basic structure of the Indian Constitution. It says that the right to, it said that, by giving reservation on the basis of, on economic basis, it violated the basic structure of the Indian Constitution or right to equality, whatever it may be, ठीक है? But अभी Supreme Court ने इसका judgment नहीं दिया गया है. So that is why I told you, basic structure doctrine is one such topic which keeps on coming again and again in newspaper articles, in judicial judgments, so on and so forth. And that is why this basic structure doctrine, the topic of basic structure doctrine, is very, very important from examination point of view. In Lakshmikant, this topic has not been explained properly. Okay? So that is why I hope you have made the notes. Okay? Now, let me briefly tell you about the criticisms. The criticisms of basic structure doctrine. You might get a question that, critically analyze the basic structure doctrine. See, number one, critics argue that the basic structure doctrine is undemocratic. Why? They argue that the basic structure doctrine is nowhere mentioned in the Constitution. The basic structure doctrine is given by judges who are unelected, who are not accountable to the people. So that is why the basic structure doctrine is undemocratic. Because in democracy, the decision should be taken by elected representatives. Judges are not elected representatives. Judges are not accountable to the people. So it is undemocratic. Then they also argue that this is the case, basic structure doctrine is the case of judicial overreach. Because through theory of basic structure doctrine, judiciary basically amended the constitution without formal amendment. Right? It is virtually, it had amended the constitution, and a power to amend the constitution belongs to the parliament. So this is the case of judicial overreach. Judiciary had crossed that boundary, Lakshman Rekha, through giving basic structure doctrine. So it disturbs the balance between different branches of government. It violates the principle of separation of powers, and it is the case of judicial overreach. That is what is the argument. Second, the critics, they basically said that the doctrine of basic structure, it does not have any textual basis. Textual basis meaning it is nowhere mentioned in the text of the constitution. It is nowhere mentioned in the constitution. So it is textually, there is no textual legitimacy to the basic structure doctrine, because it is a result of judicial innovation or judicial interpretation. It is nowhere mentioned in the constitution. So there is no, they argue that there is no textual basis. Okay? So on and so forth. Okay? These are some criticisms. Now understand that Supreme Court of India, through the basic structure doctrine, basically prevented our democracy from turning into authoritarianism. The basic structure doctrine has acted as a safety valve. And it has protected our parliamentary democracy by limiting the power of parliament to amend the constitution. It has prevented our democracy from degenerating into authoritarianism and totalitarianism. It has ensured the constitutional balance within the constitution. It has helped in upholding the foundational values and essential features of the constitution. Because without a basic structure doctrine, any government with brute majority in the parliament could have changed the basic character and identity of the constitution itself. Now it is not possible. Why? Because of basic structure doctrine. So basic structure doctrine is a landmark and historic judgment of the Supreme Court, which has helped in protecting our parliamentary democracy. The basic structure doctrine has helped in protecting the essence of the constitution, the character of the constitution, the identity and soul and heart and spirit of the constitution. That is what is the significance of basic structure. So despite its criticisms, everyone argue, even critics, they accept that basic structure doctrine, despite of its criticisms, it has helped in protecting the democracy in India. Got it? So this is what is about basic structure doctrine. No, I meant that value of basic structure took from preamble. I mean equality, liberty, those. Yes, the values like justice or liberty, equality, fraternity, which are contained in the preamble, yes, they are part of basic structure, and that is why they cannot be taken away. Now understand that Supreme Court did not say that the entire part 3 of the Indian Constitution is a part of basic structure. Not all the fundamental rights are part of basic structure. So far, Supreme Court said that only fundamental rights under Article 14, 15, 19 and 21, they are part of basic structure so far. In future, Supreme Court might rule any other fundamental rights as a part of basic structure. Okay? Fine? Got it? Understood? Fine. Thank you.